Hello and welcome to the next segment on Introduction to Agricultural Law. During the last class or the last videos, we talked about tort liability. We spent a long time on the tort of negligence, and we kind of started to get into more of the applied negligence, at least as it, you know, breaks out for premises liability. So remember, premises liability, it's the tort of negligence. Nothing is different. The only thing that's a bit different with premises liability is that we don't really look and see what is the reasonable prudent person. We look and see, well, who is the person and why are they there? Are they a trespasser? Are they an invitee? Are they a licensee? And then your duty of care is going to depend on why that person is there. And then I mentioned, remember, agricultural law is the law of exception. So now today we're going to be talking about uh, issues with particular statutes that kind of provide another type of exception to the general premises liability. So this is kind of more into the applied. So we started torts. We're talking about the broad picture. Negligence is probably the most important tort. We talked about premises liability, which is pretty important for agriculture, but these particular statutes that we're going to be talking about in the next two videos are all geared towards rural land ownership. Sometimes it's farming specific. Sometimes with the recreational use statutes, it's more about rural land. Like it doesn't have to be actively farmed at the time, but it's providing protection for those types of people. Remember, agricultural law is the law of exceptions. You can get into some really bizarre stuff when you're in agriculture, whether it's, in this case, we've got my daughter who was really enjoying being on the farm as she was shooting feed pellets at the cattle. And they were more than happy to take a feed pellet to the forehead if it meant they got to eat it afterwards. Found it highly entertaining. The cattle enjoyed it as well. So uh, when it comes to things like agritourism and recreational use statutes, people are willing to do or pay for activities that some people might consider odd, but it can definitely be a moneymaker. So, just in the way of review, remember we talked about uh, the basics of torts, we talked about negligence. Negligence has two different facets to it. It's either the failure to do something that a ordinary reasonable person would have done, or it's the failure to do what a reasonably prudent person uh, would have not done. So it's both sides of the same. It's either doing something that you weren't supposed to, or failing to do something that you were supposed to do. Either one of these can make you liable. Remember, with things like intentional torts, it's always you did something you weren't supposed to do. With negligence, it could also be, well, you failed to do something that as a functioning member of society you should have done. Remember, we still have the four elements of negligence. This works the same way for premises liability. The only thing for premises liability is we have the three duties of care, and your duty of care depends upon whether they're a trespasser. You owe them no duty of care except to not engage in willful or wanton misconduct that causes grievous bodily injury, i.e., don't shoot them and don't set booby traps. You have your licensees. You need to warn them of hidden dangers. And then finally, you have your invitees or your business invitees. These are the people that you need to make the premises reasonably safe for. That's a really hard thing to do in the great outdoors, is making things reasonably safe. So the three statutes that we're going to be talking about in this video and the next video are carve-outs that state legislatures have provided for rural landowners to try to incentivize them to open up their land to the general public. No one likes to get sued, so these statutes are basically types of protection that rural landowners can use to help incentivize them to open up their property. The other thing that we did not spend much time talking about, but ends up being really important, especially for things like agritourism statutes and liability, is that when we talk about this status of the entrant, they're a trespasser, a licensee, or an invitee, that person doesn't always stay in that same category. They can actually transition from one category to the next and then back to the previous category. So I think the easiest way to illustrate this is through an example. So someone walks up to your door and you've got a pond out back of your house. They knock on the door and say, "Hey, do you mind if I go fishing on your land?" And you say, "Yeah, go for it." At that point, they have permission to be there, but you're not making money off of them. So in that case, this person's going to be a licensee. So you have a duty to warn them of hidden dangers. They go out, they try to fish, and they don't catch anything, but they notice that you've also got some timber in the background, and they think, well, maybe you've got some deer or wild game that I can hunt in the fall. So they decide to go walk around in the trees. Well, you go out to the pond to see how this person's doing, and you don't find them at your pond. Well, you gave them permission to fish. You didn't give them permission to hike all over your property. So at this point, that person has exceeded their permission. So they are no longer a licensee. Now they've moved into being a trespasser because they've exceeded the authority that you gave them. You catch up to them, you ask them what they're doing. They tell you, "I'm so sorry, I wasn't catching anything. I just wanted to see. I thought I might ask if I could go hunting in the fall. How about I pay you $100 for the trouble that I've caused?" And you accept the money. Well, at this point, that person's gone from a licensee when they asked for permission to a trespasser when they exceeded your permission and left the pond. Now they're a business invitee because you've been paid for their being on your land. So you've got a situation here where a person went from a licensee to a trespasser to a business invitee. So what's important to know about this is you can make this work for you. So you can define where you want someone to go. And if you're doing something like agritourism, where you have lots and lots of people coming onto your property, you probably can't make the entire piece of property safe. So if you have 160 acres, making 160 acres safe is going to be next to impossible. But what you could do is say, my agritourism operation, my pumpkin patch, is going to be on 5 acres. And all of the occupants, the entrants, have the right to be on this 5 acres, but if they set foot off the 5 acres onto the other 155 acres, they are now trespassers. And your duty of care to them if they get injured is much, much, much lower. So landowners can make these work for them by either letting people onto their land or prohibiting people from going onto their land, and they can actually create liability protection. And that's going to be important as we go through uh, these lessons on landowner liability statutes. So first, I want to start a little bit on agritourism, kind of what it is, what the issues are. Agritourism, it's been around now for 2 or 3 decades. And basically, what it is people that did not grow up around agriculture going out and seeing a farm. So this could be things like a pumpkin patch or a corn maze. It could be a dude ranch. It could be goat yoga. It could be you pick blackberries and strawberries. The list goes on and on. Some states classify, barn weddings as agritourism, hay rides. You know, uh, it seems like the list of new and innovative agritourism events just keeps on expanding. This has become a pretty important part of a lot of farms' revenue. This can be a pretty lucrative business, especially for things like wedding venues. I mean, some of the wedding venues that I know of, using old barns, they bring in hundreds of thousands of dollars a year. Pumpkin patches, not so much, but the wedding barns right now, that's been the trend the last few years. State governments have encouraged this. It's another revenue stream for farms, especially smaller farms. But there are some issues that come along with these agritourism operations, and I mean some of them are your normal business concerns, marketing, creating interesting activities to incentivize people to go out. But the other thing they highlight is you also have legal risk, and that's because Arkansas is not or sorry, agritourism is not always the safest thing to be involved with because agriculture can be dangerous. So if you notice, I got uh, uh, the paragraph here about legal concerns from 2012. Back in 2012, Arkansas actually had two fatalities on agritourism operations in one year. Uh, it's pretty common. There are several fatalities across the country every year, and there are numerous people that get injured at agritourism activities. When I go to large agritourism conferences and speak, one of the things I will do is usually ask the crowd, how many of you guys have been sued for someone that has been injured or killed on your farm? And typically anywhere from 40 to 60% of the audience will raise their hand. So, uh, liability concerns, tort liability concerns are a major, major impact on their operations. What is agritourism? I've mentioned several different ones. Usually, it's about education and entertainment. Uh, I've seen states try to list all the different activities that could be agritourism. The problem you run into is people are so creative that they are creating new activities faster than state legislatures can update the lists. So a lot of them just kind of give these generic definitions like this. But basically, some kind of tying a working farm with education and entertainment. Here's a picture I took out of one of them. This was a pumpkin patch. Uh, this particular gentleman had so much business. I don't, you've probably never been around pumpkins before, but typically when pumpkins turn orange and are ready to harvest, the vines that they are on are dead. This guy couldn't grow enough pumpkins. His agritourism operation was growing so fast. So what he did was he planted just regular vines out there in the field, and then at night, you can see the road on the side, a semi would come in and the pumpkin fairy would go out there and spread pumpkins out throughout the patch. And the next morning, hordes of kids would descend like locusts and carry off all the pumpkins. And the next night, the pumpkin fairy would come back again and, you know, dump more pumpkins in the field. So, you know, they're not always perfectly accurate depictions of what agriculture is, but for a lot of people that don't know any better, like this may be their first time to see a pumpkin actually in a field, even though these weren't grown in that field. These have been a big component for bringing in extra money for farms. Uh, for some states such as Arkansas, we've got a long history of berry production, blueberries and blackberries. Used to, those were all sold commercially. People would come in, usually H2A labor, pick them. They'd be put into clamshells and they'd be sold at local grocery stores or grocery stores across the country. Finding labor has become much more difficult, so a lot of the Arkansas berry operations have switched over to you pick berries, where people will go out there and pick their own berries out of the field. A lot of the farmers still believe they are commercial operations, but they're not. This is actually a value added component of because people want to harvest their own berries. So people are willing to pay for the experience of picking their own berries. So the farmers are being able to avoid the labor costs and they're able to get, some extra money by having people pay a premium for the experience of picking their own berries. Uh, Agritourism's really exploded in the last couple of decades because you go back to the 1930s, 1940s, about half of the American public lived or worked on a working farm. Nowadays, we're slightly under 2% of the American public is directly involved in agriculture. So you ask people where their food comes from, and the standard answer is, well, a grocery store, of course. They don't know, uh, some people, there's a lot of people that have never seen livestock in real life. They've never seen growing fruits and vegetables. So this is a chance for them to connect with, how the food they consume is produced. But like I said, liability is a major issue. And the other picture there is goat yoga in the field. I thought this was a joke the first time I heard of it, but no, it's not. There's actually quite a few people across the country that will pay very good money to go out there and do yoga while goats climb all over them. The other reason I like to go through these statutes is one, we're talking about torts, and it's good to kind of get this implied torts. But the second thing is, we've talked about statutes in this class. We've talked about the Constitution, statutes, regulations, but this is the first time that we're actually going to look at legislative language. These are the actual statutes that make up the Arkansas, or in this case, the Arkansas Code. And we're going to spend a little bit of time, a couple of times throughout the semester, we're going to look at specific statutes, how you read them, what they're looking for. So, uh, most statutes will start off with some kind of section of legislative intent. This is pretty common, whether it's agritourism or right to farm or you name it. Other types of statutes usually will include this legislative intent section. And usually they don't have a whole lot of legal impact. This is a section that lawmakers typically pat themselves on the back, say that we've recognized this horrendous problem and we've passed this beautiful piece of legislation to protect all of the citizens of our great state. But sometimes they can be useful if judges are trying to interpret them. So, for example, in this one, the first bullet point under sub A talks about uh, some of the basics of what they think agritourism is, the state legislature. But probably the most important part of this one right here is B. So basically it's a, hey, we've put in these protections, but we expect courts to liberally construe this bill to give people extra protection. We don't want courts to read this narrowly and make it easier to sue these agritourism operations. So this would be like a good example of a legislative intent section. So we can see here it's all about providing or limiting civil liability for those engaged in agritourism. So I've mentioned that this is an issue, and the issue is there are types of common law doctrines that help protect people from being sued. So one of them for the tort of negligence that we haven't talked about so far is called the assumption of risk doctrine. And the assumption of risk doctrine is exactly what it sounds like. If you knowingly do something that is risky and then you turn around and you get hurt, you shouldn't be able to sue the other side because you knew that what you were doing was dangerous. So this only works with things that are well known to have a risk of injury with them. So the example I like to give is football. We're an SEC country. Even if you've never played football a down in your life, you realize that football is a contact sport and that people get injured playing football. I have never heard of a case, and I don't think it's possible to ever hear of a case where one football player is injured on the field and they turn around and sue the player from the opposing team for injuring them. It can't work, and the reason for that is when that player strapped on the pads and put the helmet on and set foot on the field, they knowingly assumed the risk of injury. Everybody in the stadium, everybody watching on TV knows that on any given down, one or more people can possibly get hurt. It doesn't matter if you've ever played football in your life. Football is well known enough in the United States that everybody knows this. What about agriculture? Well, not so much. I mean, if you go back to the previous slide, less than 2% of the American public have any day-to-day impact with agriculture. So you end up with a situation where courts have been saying, you know what, if someone comes out to a farm and they get hurt and they're out there for agritourism, they can't knowingly assume the risks of agriculture because they know nothing about agriculture. Like they are coming out there to be educated about where their food comes from. They can't assume the risks because they don't know anything about the risks or how a farm works. So assumption of the risk has not been a very useful common law defense for agritourism operations. How dangerous is agriculture or agritourism? Well, it could be pretty dangerous. Uh, the example right here, there was a petting zoo, and a mama camel had just given birth, and she decided these two gentlemen were threats, and she actually stomped both of them to death. Uh, the cops showed up. They tried to render first aid. The camel ended up attacking a patrol car. Then she noticed that the cops were rendering aid to the people that she had just previously stomped to death, and the mama camel went after the police officers, and she had to be put down. I mean, that's just, every year people are killed in hay rides and falling from barns and uh, injuries from zoonotic diseases like E. coli, salmonella. Agritourism can be pretty dangerous. uh, Agriculture is actually one of the most dangerous jobs in the country. I'm using the numbers for 2015 because I know for a fact this number is not correct. I had a family member who was killed in a round baler accident uh, that year, uh, but they marked it as natural causes because they didn't have time to do an autopsy. So I know that number was at least 402. How does that compare with other, probably better known occupations? FBI reported that there were 86 law enforcement officers killed in the line of duty that same year. So that's both like shootings and high speed chases. So over four times as many people were killed in farming related accidents as law enforcement officers. So, most dangerous occupation, a lot of people will guess mining, forestry, agriculture. Those all kind of bounce around as two, three, and four. The most dangerous occupation is truck drivers, specifically long haul truck drivers. It's just driving is dangerous, and they drive a lot. So, so you end up with agriculture being a very dangerous occupation, usually two, three, or four when it comes to fatalities and maimings. And then you bring in agritourism. So people know nothing about agriculture. A lot of them don't. I was at an agritourism event, and it was an agritourism workshop being held on a working agritourism operation. So one of the workshop sessions, we went out there and followed a group of people that were, you know, touring the facility. It's really cute when a 5-year-old asks which dairy cow gives chocolate milk. It's not as cute when it's the 30-year-old dad is asking which one of these dairy cows gives chocolate milk straight from the teat. It just kind of goes to show you that there is a real lack of knowledge. And it's this lack of knowledge that's driving the interest in agritourism. The problem is, if there's no knowledge, you can't knowingly assume the risks of injury, and this is a pretty dangerous business to be in. So, what states like Arkansas have done, and we're up at like into the, we're over half the states have passed one of these statutes now. Arkansas has basically changed this assumption of the risk doctrine. They've codified it. So they've put it into law. So now it's no longer left up to the judge on whether or not they want to recognize the defense. What a judge has to do now is they have to read the statute, apply the factors that the Arkansas legislature has put forth, and if the agritourism operation meets all of the criteria that the Arkansas legislature requires, then in this case, they are forced to say that the participant assumed the inherent risks of agritourism activities. So what does an agritourism activity operator have to do? Well, it's got to be due to an inherent risk of agriculture. If you're out there, randomly shooting a gun or something like that, and you shoot somebody, that's not an inherent risk of agriculture. That's just someone being crazy. So it's got to be tied to an agricultural activity. Arkansas requires that you have a warning sign posted as well. And then finally, if there's any other defenses, you get to use those as well. So, in general, does posting a warning sign work? And the answer is no. Typically, warning signs are not worth the paper that they are printed on. It's not that uncommon, though, to go into a small shop and you'll see a sign hanging up saying, hey, not responsible for slip and falls or things like that. Those signs are worthless. Um, the reason people put them up is that if you fall and hurt yourself and you see that sign, they're hoping that you're going to think, wow, I probably would have sued him for the dangerous shop, but the sign says he's not responsible, so I'm just going to go home and suffer in silence. If you go to a lawyer, the lawyer's going to laugh when they hear about the sign. The sign is worthless. So it's basically what they're doing is hoping that they can trick people into not going and seeing a lawyer. Warning signs typically don't work at all. The exception is if you have a sign that says, or you have a law that says warning signs work or warning signs are required, and then in that case, warning signs do work. So for agritourism and for next class for equine activity statutes, the state legislature has actually said you must use a warning sign, and they actually give you the language that you must put in the warning sign in order for it to protect you. So that's the warning signs. We'll look at the language here in a little bit. So it only prevents against inherent risks. So what is an inherent risk? Well, the Arkansas legislature in this case was generous enough to define what are the inherent risks of agritourism or agriculture. So we've got wild or domestic animals that might injure someone. So this could be things like a snake or a bee, or it could be a horse or a goat. Um, we'll talk about there's some limitations to this later on, but animals can be dangerous. Hazards such as surface and subsurface conditions. So these are going to be things like potholes, things like that someone could step in and break a leg. Natural conditions of the land, so vegetation like tree roots that someone may slip over, poison ivy, water that someone may drown in. Those are all going to be covered. Ordinary dangers from structures or equipment. So that's going to be your barns, your farming equipment, hay rides, things like that. And the last one is interesting. The potential of another participant to act in a negligent way that may contribute to injury or to that participant or others, such as failing to follow safety procedures or failing to act with reasonable caution. Basically, it's a protection against other people on the other customers out there doing something dangerous. So what do we mean by this? For things like corn mazes, um, I've seen it before. You have a group of teenagers go in there. The first thing they do, they start picking ears of corn off and they start throwing them at one another. If one of those teenagers throws an ear of corn and they put out someone else's eye with, with a corn cob, uh, there's gonna be protection for the landowner. It's not his fault. It's teenagers being stupid. Well, what is agritourism activity? Like I said, because these are so ever evolving, most states go in and just put in a pretty broad definition of what could be agritourism. So in this case, we've got food production, nature watching, historic traditions, education, entertainment, or recreation. This covers a pretty broad swath of things that you could do out there that would be covered as an agritourism activity. Here's kind of the breakdown. Also includes, the first one we've already seen, or first two we've already seen. Harvest your own activities, so that's like the berry picking and things like that, apple picking. Nature watching would be like bird watching, things like that. And they also include animal exhibitions at fairs. So these are your animal exhibits, the sheep barns and things like that at the county and state fairs. They are very clear, though. This applies to agritourism. It doesn't is not meant to protect retail sales. So if you have a roadside fruit and vegetable stand that is not located on the farm, and going back to those examples, my dog's out there digging potholes in front of my roadside stand. This agritourism statute's not going to protect it because people aren't going out there to be educated or entertained. They are there to buy produce and then to leave. So if you have the roadside fruit and vegetable stand on your farm and people can walk through your vegetable garden or things like that, that's going to be agritourism. But if it's completely separate from your farm, people just show up to buy produce and then leave, it is not an agritourism activity. uh, the one under it, the operation is exclusively devoted to the sale of merchandise. I call this your grocery store exception. uh, Grocery stores don't get to go out there and hang educational signs in the store and claim that they're educating the public about agriculture and then get liability protection. No, they need to, keep their store clean and purchase insurance to protect themselves because people aren't coming there to be educated or entertained. They are coming there to buy food and then to leave. So there are also exceptions to the exceptions. So we talked about the protections that the agritourism statute provides. There are some things that are not protected. And if you think about this, it does make sense. So uh, the first one is commits gross negligence. So far we've talked about negligence, the failure to act as a ordinary and reasonably prudent person would do. Gross negligence is way beyond that. It's not just failure to do what a normal, reasonable, prudent person would do. It's you did something really dumb. Uh, Usually, gross negligence is one of those things you don't have to define it. This is one of those things everyone looks at it and says, "Wow, that was a really dumb thing to do." Um, an example of gross negligence: uh, you're going to take people out duck hunting and you're leading the way out to a duck blind and you have your loaded shotgun over your shoulder with the barrel pointed back to the group, swinging back and forth with your thumb on the trigger. Like that would be gross negligence. That's a really, really dumb thing to do. If the shotgun goes off and injures someone, it's not that you intended to hurt someone, it's just that you were being so grossly negligent that it's completely foreseeable that you're going to hurt someone, and there was no reason why you were doing what you were doing. So, gross negligence is usually pretty easy. The facts have to be pretty egregious, though. Um, if the farmer has actual knowledge of a dangerous condition but doesn't fix it. So you've got a barn. Remember, going back to the examples, structures and equipment are an inherent risk. So a farmer has a barn. The farmer knows that one of the steps on the barn is broken. And the farmer knows that they need to go out there and fix the steps, but she just doesn't have time to do it today. Someone steps on the broken step, they fall through it, and they break their leg. The statute is not going to protect the farmer because the farmer knew about the dangerous condition and did not fix it before someone was hurt. The third one's pretty common sense. Like if you intentionally hurt someone, it's not going to protect you. Like this is meant to protect against negligence. If you take a baseball bat out there and start hitting your customers, like one, it's a bad business decision, but two, that's not negligence, that's an intentional tort. That's battery. So no protections given for intentional torts. And then finally, the last one is kind of goes back up with gross negligence. It's actually the definition of gross negligence. Errors or omissions that constitute willful or wanton misconduct. It's more of a catch-all or criminal conduct. If you do something really, really bad, the statute's not going to help. So let's look at the sign itself. So in Arkansas, they give you the exact language you have to use on the sign. And it basically starts there at that second bullet point with the word warning. Your sign has to be these exact words in this exact order. You can't add to it. You can't take anything away from it. It has to be this exact warning sign. If you're missing anything in there, the judge can throw out the agritourism statute. So not only that, but if you look at the bullet point above, these signs must be posted at or near the main entrance and in black letters at least 1 inch in height. So even the lowercase letters have to be at least 1 inch tall. So this is a pretty decent sized sign. Uh, my recommendation to people is lawsuits are expensive, signs are cheap. So I wouldn't just do one sign, I would buy 5 signs and I would post them at the entrance where people sign in, the middle of the corn maze. Like I would scatter these things all about where people are at because you want the warning sign requirement to be checked off. Some state Some operations also have written contracts. If you've got a written contract, you need to have this language in the written contract as well. You don't have the 1 inch height requirement in the written contract, but it's got to be big enough that they can read it. You don't typically see a lot of agritourism operations with written contracts, the exception being liability disclaimers, and those usually only work with operations that are high risk and low volumes of people. So for example, you've got a pumpkin patch, but you've also got a zip line set up above the pumpkin patch, and you only let adults do the zip line. You may have 300 kids come to your pumpkin patch every day. Well, it's going to be impossible to get 300 kids to read, sign, understand, and sign written liability waivers. But if you have 20 or 30 adults that do the zip line a day, you could definitely have them read, understand, and sign the liability waiver uh, in case they get hurt on the zip line. So these written contracts are kind of situationally dependent. For high volume, low risk activities like pumpkin patches and corn mazes, nobody signs waivers. But for things like zip lines or other really dangerous activities, a signed liability waiver or contract probably is not a bad idea to do. Let's do some examples. Local agritourism operation. A couple of college kids feed a goat wine, chase it around the pen once it's drunk. One of the kids trips and gets a horn shoved down his throat and has to go to the hospital. Oddly unique circumstance. That actually was a situation that I witnessed growing up. Thankfully, I was not the kid that had to go to the hospital, but I knew the one that did. So in this case, let's assume that happened at an agritourism operation. Is the agritourism operation protected? Probably so. Remember, is it an inherent risk? We're going to be protected uh, from injuries from animals, and if an injury is tied to the negligence of other participants, then that also is an inherent risk of agritourism. So the one thing that could change this first hypothetical is if the agritourism operator or one of their employees was actually watching all of this and didn't stop it. So if you know that a dangerous situation is starting to develop, you need to go out there and prevent it from happening. But if no one that worked for the agritourism operation was witnessing what was going on and all of this stuff happened, the agritourism statute is going to end up protecting them in this situation. Let's go into the second bullet point. Later on, no one's watching as a 5-year-old climbs into the goat pen after the goat sobered up and is attacked by the billy goat. So once again, the statute is going to protect against actions by animals. Now, Remember, on the exceptions, though, there was one: if the farmer knows that there is something is dangerous and doesn't fix it, then the farmer could be liable anyways. So if this goat has attacked people in the past, has a history of attacking people, you've got to get rid of the goat, because otherwise that exception could make you lose your protection. But assuming that this goat has not been out attacking people in the past, the 5-year-old that gets into the pen gets injured by the goat, the law should protect the agritourism operation. And then the last one is a person falls off a hayride and they are ran over by the trailer, which ends up killing them. Unfortunately, this happens about every year in the country. Like, there's usually 2 or 3 people that fall off hayrides and are run over or die from the fall. This is not that uncommon. It is an inherent risk. So long as there's nothing broken on the trailer or tractor that causes the person to fall off, agritourism statute's usually going to provide some protection. So these statutes have been enacted by state legislatures with the purpose of encouraging farmers to open up their land for agritourism. One, it helps to bring in money for the farms, but more importantly, from the state legislature side, you're giving people a chance to reconnect with the outdoors, see how their food and fiber is produced. So the state legislatures, when they pass statutes like this agritourism statute, they are basically balancing the legal interests of the farmer versus the participants. And they are skewing the protection in favor of the farmer to encourage them to open up their land so that the participants will have the ability to see these kinds of things in person and not just have to rely on YouTube videos to see, what happens on a farm. But, it is skewing the legal risks from one party to the other. So you can get into situations where you may have a situation where it does not look fair. But what they're doing with these statutes is they are trying to create some certainty to open things up and make farmers more willing to let people on their property. From a technical aspect, I will say that these statutes are by no means perfect. It looks like they provide good protection, but I'm telling you that a good lawyer can usually find some facts that they can try to break in one of those exceptions. So um, good lawyers will keep digging until they find something. Aha, the farmer known or should have known that this was a defect. The agritourism statute should get thrown out. And that does happen pretty frequently. This is by no means the main type of protection for those operations that are doing agritourism. The first and best line of defense is insurance. This is kind of a distant layer of protection. People that are relying only on the agritourism statute, they are eventually going to get sued and they will be sued out of existence. So insurance is by far and away the best type of protection for these things. But the agritourism statutes, they exist and they do provide some protection out there for farmers. But it really is it's factually dependent on, when these things can come into play. So as always, if you have any questions, please feel free to send me an email. I'd be more than happy to hop on a Zoom call or on a phone call with you.